Hello, everybody. We are reviewing MEEs. We are issue spotting and probably just talking about black letter law for time purposes to get through all six, instead of a full MEE like we've been doing in the past, because this is the review for the last week, for the February 2026 bar exam. So let me get my highlighter out. And what I thought would be helpful is as we're looking over this MEE, I think what a lot of people get caught up in is when there's a lot of parties, right? When there's, like in this situation, two brothers, sister, brother, sister, cousin, um, there's a contracting party for tires, there's a person buying the farmland, right? Sometimes we have more than that, right? We, especially in real property deed recordings, we have A goes to B and B goes to C and C goes to D and so on and so forth. Um, so if we have those types of MEEs where there's just a lot of parties that we want to get situated, I think a something that can help a lot of people get their footing when they're reading an MEE, and I understand that on test day, when we read this for the first time, it's going to be like tenfold experience, right? Because we're sitting there, it's like that day, right? There's going to be a lot of emotions that day, and we're going to try and have our minds right when we're reading this thing. So I think I've probably talked about this, but I'm a big proponent on earplugs. I'm pretty sure all jurisdictions allow them, but I would check with your jurisdiction. But the foam earplugs that you just roll up and put in, I think makes all the difference of just to get the outside sound away from you. You don't know who your neighbor is going to be. You don't know if they're a loud typer, or they're sneezing or whatever. You kind of just want to be as focused as possible with the conditions that you're given. Obviously, we're not in the comfort of our room. We're not in the comfort of our local library or our kitchen or whatever like that. Um, Not some place that we're used to. So we want to anticipate that we're not going to be completely focused as we would be in our room. So with that said, I think what would be helpful is if we get very overwhelmed or we're reading something and we're like, I have to read this 5 billion times, I'm not sure who's who. I'm in my scratch paper on the side. I'm going to say, who is B, right? Who is A? Who is C? And then I'm going to put a little asterisk here, right? Um, they're a member of the LLC, right? At this point, I'm just kind of making up because I didn't read it yet. B is the buyer, right? A is Adam, whoever the people are. Just so I understand my parties, because I think the parties are the first hurdle to go through. Because when you see transactions going on and then you see, is A liable to B? I don't know if A is liable to B because first I have to find out who is A and who is B. Is A the debtor or is A the deadee? Right? Did A contract to paint the house or did A um, ask their house to be painted? Right? These are big changes that, depending on what MEE we're given, can really focus us on getting the correct answer. Because if we don't know who our parties are, when we scroll down and they say, um, was the LLC bound by the sale of the farmland? Right? I need to know who's in the LLC, what they did, and what happened in that conveyance of the farmland, right? I want to be situated. I want to understand what's going on. And even if I'm not saying we have to know the answer, right? That is definitely not what I'm saying. I think it's totally reasonable to not know the answer until we go through the analysis and we get to the end. And I've said that before. I think one thing we really do want to know is like, what is going on? Like, what is this story trying to tell me? And I think that will get a lot of stress out of what we're going through, just by the mere fact that we have understood who is who. And I think in this MEE, it's kind of like a little bit more simpler because there's an organization and stuff like that. But in the other MEEs that we'll go through, you'll see what I'm talking about with like who is who. Um, okay, so let's go through it. And after we're going through it and maybe even paragraph by paragraph, I'm going to go over what the issue spot is, and I'll give people, if they want to, an opportunity to say it if they want to. I understand people don't want to. It's late. Don't worry about it. Um, but, think about it. I'm not going to jump into it. Let's think about it. Be like, what could I possibly write about in this situation? Okay. So, two siblings, brother and a sister, decided to start a bike shop with their cousin. So once I read that first sentence, I'm probably in some business entities type of MEE, right? Either a partnership or an LLC or LLP. I can kind of just like quickly glance down and see I'm an LLC, but why do I care that it's a bike shop? Without jumping ahead, maybe they tell me that something is done through ordinary course of business that is involving bikes, and maybe something is outside the ordinary course of business, meaning it's not involving a bike, right? I have to know what type of business it is. I want to know that they're selling bikes. Um, with their cousin, right? So I have three parties in LLC. Maybe that comes up, right? I want to know what's going on. They filed certificate of organization to form a limited liability company. Seems like they did all the formalities that they need to. I'm not going to fight the question and be like, oh, well, maybe the filing document was incorrect. If it's not pointing to that, if the facts don't give me that, I'm not going to hone in on something that's unimportant like that. And the other LLC that we went over together when we had our agency and partnerships lecture. Remember when we had an issue about the LLC, right? Because it talked a lot about it, right? They failed to file the articles of organization. They didn't file with the Department of State. So if they don't do that, then we have a general partnership, right? That's the default. So that would be a question where we're talking a lot about the defects in filing, probably would be a question. But here, because they're just straight up telling me that they filed something, I'm probably just going to take it. Um, and I may not be told something that's that important, right? All I want to know is that the LLC was filed. It was created. So brother and sister paid for the LLC member interest each by contributing $100,000, right? So we know that just like in partnerships, when we have an LLC, the members of the LLC can contribute monetary amounts in cash, they can contribute property, right? Whatever they contribute to the organization is their fair equity in that organization, right? So um, the reason why that may come up is when a party wants to get out, what is their fair share of the equity in this organization, right? Is it an agreement that's in our documents that tells us what that interest is, or was it just their amount that they have provided, right? So when you contribute cash or you contribute property, in return, you become a member of the LLC and you're able to run the company and you're able to get profit from it. So that's why we just want to make sure that, why does it, what does this mean? Like when I get $100,000 and then I put it in an LLC, what does that mean? Well, now we know that that's how you become a member and that's how you get equity in that membership. That is your fair share of the LLC or the partnership if it was a partnership, right? Because what's the difference? An LLC has different structure, right? We have member uh, member LLC or member manager LLC. And then the only difference is that we have limited liability, right? We do have filing requirements, we do have different structures, but the whole point of an LLC is we have limited liability. And so that's why people who are creating a general partnership want to go through the extra steps to make the LLC, because if someone in the LLC gets sued, you yourself do not have that much liability if you had an LLC. Compare that with a general partnership. If your fellow partner screws up, you could also be on the hook, right? But for an LLC, not so much. So LLC then recorded the deed. So what did they record the deed to? Before I skip that, the cousin paid for the LLC member interest by conveying the LLC 5 acres of farmland valued at $100,000. And then the deed was recorded. So, like I said, you can contribute cash, you can contribute property, anything of value, you can contribute to the business, right? And then that is your fair share of the equity. It's also nice that they're making it the same amount as the cash. Because then it looks like they have equal interest, right? We have a third each, 100, 100, and 100, because they each contributed 100. Neither the certificate of organizations nor the members' operating agreement specifies whether the LLC is member managed or manager managed, right? The two types of LLCs that we have. However, the operating agreement provides that the LLC farmland may not be sold without the approval of all three members. So if I have a specific statement in my documents for my LLCs or my partnerships or my LP, whatever, in my operating agreement or in my articles of incorporation or my certificate of organization, whatever my organization is, if I have something in there that says the members cannot do this without this, okay, that is my new rule, right? Because we have our default business entities rules, right? For, um, the uniform partner laws, typically our MEE will say this jurisdiction has adopted the uniform partner laws or whatever. We have those, but if I don't have my default rules, my members can write around it, right? They can create a document that says something else. They don't have to go through the default rules. They can change them, right? And it's just like mailbox rule or just like statute of frauds or something like that. We have those default rules, but you can write in your contract, we're not going to follow that, right? So certificate of organization or operating agreement are also documents that the LLC needs, just so we know. And then member manage or manager manage are two different types. And the agreement is not specific what it is. Maybe I'm going to be asked what different structure I have if the agreements are silent. Spoiler alert, member managed is the default. Why is it not manager managed as default? Because you have to hire a manager. It would say that blah, blah, blah is hired as the manager. We'll see that we don't have that in this MEE. That's why I know my default is member managed, and that's probably something that I'm going to want to talk about. So following formation of the LLC, the company rented our storefront commercial space for the bike shop, opened up their business. 3 months ago, purporting to act on behalf of the LLC, as soon as I see something like this, I'm probably going to be asked about agency. What is agency? When you purport to act on behalf of the organization or the company and you go do something, right? You buy something, you lease something, you mortgage something on behalf of the company. Then we need to know if that member slash partner, and again, all of this can still be the same type of analysis in a partnership. Just because we have an LLC here, it just changes the words, right? But I still have agency, I still have a parent versus actual authority. But I'm just now talking about members instead of partners, right? So I just want to make sure everyone knows that this is still likely going to be the same exact paragraph as long as I'm in business entities, but my changing of the names is like the most important part that I want to know. So when I'm writing my MEE answer, I'm going to want my grader to know that these are members, right? This is an LLC. I don't want to talk about partnerships because that's not what I have here. So I think calling the people and calling the entity the right name can actually take you a lot farther in your answer, because your grader understands that you know what you're talking about. So, purporting to act on behalf of the LLC, brother entered into a written and signed contract to purchase 100 bike tires for $6,000 from a tire manufacturer. When the tires were delivered, sister said they were too expensive and told her brother to return it. The brother was surprised by his sister's objections because twice he had purchased tires for the LLC for the same price from the manufacturer. Neither his sister or his cousin has objected. Brother refused to return the tires, pointing out they're perfect for the bikes that we sell. The sister responded, well, pay the bill with your own money. You bought them without my permission. Brothers responded, no way. I bought them for the store. I didn't need your permission and the company will pay for them. To date, $6,000 has not been paid. Why do I have all this background information on he's done it before without objection? Because that is great to weave into my facts when I talk about the differences between apparent and actual authority and the fact that this is within the ordinary course of business as a purchase. Therefore, the member LLC that is purporting to act on behalf of the LLC when he makes this transaction within the ordinary course of business because they're bikes and they have a bike shop, it seems that he does have either implied apparent authority or, implied actual authority or apparent authority from the third party that he bought the bikes from, right? From the manufacturer. And so, again, what is the difference? If I have actual authority, I either have expressed or implied. Expressed is another member or a fellow partner um, specifically tells me to go do something, or it's specifically written in the agreement that brother has the right to purchase bikes whenever he wants, right? That would be expressed actual authority. Seems like he doesn't have that because they didn't specifically go tell him to do it. They just didn't object, right? So omission and not objecting is not the same as expressly going to be told to do something, either in an agreement or orally. Actual implied is something like this, right? If it's within the ordinary course of business, then a member of the LLC who has interest in a business that sells bikes has implied authority, implied actual authority, to go do this transaction, right? And if not that, then what is my other one? Apparent. That's in the mind of the third party. So it'll be the mind of the manufacturer. Does the manufacturer believe that the brother is purporting to act on behalf of the LLC? Seems like he is, right? Because he has purchased it 2 times before, right? And why would the manufacturer have any reason to believe he cannot do this transaction? So, in sum, that is what my issue spot is coming from here. I have an authority question. I have an agency question. Okay. So then what happens? 1 month ago, purporting to act on behalf of the LLC, the cousin told the LLC farmland to a third, the cousin sold the LLC farmland to a third-party buyer. The buyer paid $120,000, which was well above the land's fair market value. Only after the cousin deposited the sale proceeds in the LLC bank account did the brother and the sister learn of the sale. Both of them objected. So, um, what do I have going on here? Um, Typically, an LLC member can once you transfer, like we said, once we transfer property into the LLC, that is an interest in an LLC, right? Because that is your property that you put in there that's now owned by the LLC, and the fair market value of that is what your interest is. So seems like if nothing else was happening here, um, the LLC, the cousin selling on behalf of the LLC, may not have a problem, right? However, I want to talk about agency as well, right? Because this is outside the ordinary course of business. They have nothing to do with farmland if you have a bike shop. So if I'm doing a transaction that's outside the ordinary course of business, then I need a expressed authority to do so, right? Expressed actual authority. And so what is my problem here? I don't have that because when they created their operating agreement, they said that it cannot be sold without approval of all three members. And that's exactly what I do not have here. So I want to talk about typically outside ordinary course of business, all the members must agree. There must be expressed actual authority. But in this situation, I do not have that. I actually have documents in my operating agreement that specifies no one can sell the property without approval of all three members. So it seems like you cannot be bound by that transaction. Okay. Um, so that is what we're issue spotting there. 1 week ago, the brother wrote in his email to his sister, I want out of our business. I do not want to have anything to do with the bike shop anymore. Please send me a check for my share. So what is the brother trying to do here, which is similar to the other LLC one that we have? Um, so in this situation, we are trying to leave the LLC, right? The brother is trying to give up his interest in the membership. He wants to dissociate. That is the language that we want to say for an LLC member dissociating from the LLC. Um, we do have some, if we remember it, some specific black letter law about a member of an LLC dissociating. Um, and it's typically when they're still liable for debts of the LLC. So a dissociating member will remain liable for debts and obligations of the LLC until notice is given to all the creditors or 90 days after filing a notice of the Secretary of State. So that is something that I want to know for LLCs because of that specific filing requirement. And again, that's only relevant to potential creditors of that dissociating member as it relates to the LLC. So again, that dissociating member, when he's trying to leave, is like, I don't want any creditors coming after me. So I'm going to give notice to all these potential creditors that we have, debts that are outstanding, that I'm dissociating. Or instead of doing that and telling every single one, I'm just going to file something with the Secretary of State saying I'm dissociating. And then 90 days after filing that, I'm off the hook, right? So that's something that I want to issue spot when I'm looking at a dissociating member. We also want to know that members of an LLC can dissociate anytime that they want, right? Unless the operating agreement or the specific document saying that the LLC is continuing for this specific time, or no one can dissociate unless this specific goal is met. It's similar to an at-will partnership, right? It's not called an at-will LLC. We're just saying that a member can dissociate at any time as long as he unequivocally expresses his intent to dissociate. And it seems that's what he's doing, right? And so that is my fact weaving that I'm going to say is how do I know that he's expressly, showing his intent that he's unequivocally, right? Unequivocal is a word that they like to say. Um, Especially in anticipatory repudiation. They love the word unequivocal, and that means like without a doubt. So he is saying he wants out of the business. I want nothing to do with the bike shop anymore, right? That to me is an unequivocal statement that he wants to dissociate. Therefore, that triggers that dissociating thing that we want to worry about for creditors as regards to debts. Um, so and yes, limited liability partnerships, very, very similar. But again, if I have an LLP, what is my P at the end? It's a limited liability partnership. So if I have any type of partnership, I want to make sure that I switch my mind into thinking about partnerships, right? I have at-will partnerships. Partners can leave the partnership. Um, Whenever they want. That triggers a dissolution of the partnership unless the remaining partners expressly want to continue. So I have different terminology for a partnership. I don't have to file anything with the Secretary of State or Department of State like I have to file with an LLC. The only difference between a general partnership that we've talked about a lot and an LLP is you have a limited liability partnership, which means that you get to have limited liability where if your partner screws up, you're not necessarily on the hook like you are in a general partnership, but you still have the terms and the rules that a partnership would, right? So again, I think something super important is when I'm talking about a partnership, I want to talk about partners. I want to talk about at-will partnership. If I'm talking about LLC, I want to talk about members. Either it's member managed or it's manager managed. And we know the default is member managed. And how do I know that I have a manager managed? I start hiring some managers, right? And then, yes, Dina.
Sorry, so when you said the dissociated LL, so if a partner wants to dissociate from an LLP, is it, I remember that you can either uh, file it in a newspaper and that's like valid for 90 days as a notice to creditors, or that you can send like mail directly to the creditors. With an LLC, there is an option to go and file it with the state as well.
Yeah, so dissociating from an LLC, you have that requirement for the creditors as well. I would
Okay.
check if that LLP still has the requirement to file. Typically, LLCs have the requirement to file, and the
Mhm.
LLP might just be you can dissociate at any time. There's nothing that you have to file. I would just
Okay.
check on that because
Okay.
the filings come from the creation of an LLC. But typically partnerships, like even limited liability partnerships, if it ends in a P, it's a partnership. Those are
Yeah,
kind
yeah.
of like hands off. Like the the state is not involved. You don't have to file anything typically. Um,
Okay. Okay,
but
got it.
this notifying creditors and having that 90 days if you do file, that is with this LLC that we're talking about.
Okay.
Um, okay. So now I have my questions. What type of LLC was created? Just like we talked about, right? We have our default member managed because we don't have express language saying we have a manager managed. Are we bound to the tire contract, authority within the scope of business, within the ordinary course of business, excuse me, LLC bound to the sale of the farmland? We have authority. We are outside the ordinary course of business, but we also have that specific language in our operating agreement saying we need all members to agree, which we don't have. And what is the legal effect of the brother's email? We have a dissociating member. We need to know the requirements of dissociating and what happens to a dissociating member. Also, he gets his interest back. So, the dissociating member is able to get his interest that he gave into the LLC back. Okay, so he's able to get his $100,000 back if that was the amount that he contributed to in the beginning. That is his interest that he's entitled to a buyout for. Okay. Um, any other questions before we move on?
Rebecca, hi.
Hi.
I have a question. It's not necessarily related to this MEE, but MEEs in general.
Sure.
So I just wanted to know, so say you forget or you can't recall something on as you're writing, like what is your best advice for that when it comes to like,
Sure.
yeah.
We actually just talked about this in the last class, which has definitely happened before. But the typical situation that would happen is if so you either are issue spotting and you know that there's this specific problem that I just don't remember the black letter law for, or we can't issue spot, right? We have no idea what's going on. So those are two different things, right? So if we can't issue spot and we have no idea what's going on, I want you to let the answer choices, I mean the questions, guide you, right? So if I'm so confused, then I'm just going to, start my IRACs. I'm going to start with my issues, rewrite my issues, and try and come up with something. And then typically, if I can't issue spot, these will kind of tell me where the problems are that I should be looking. And if I have a super broad, like are the causes of action, or is this constitutional? Just a super broad one. If I'm failing to issue spot and I have no idea what's going on, I'm going to just pick certain words that I am jogged my memory from studying. And if it's like free speech, I'm going to talk about free speech, right? If it's an equal protection, I'm going to talk about equal protection if I see something like that. So that's if I can't issue spot. I just pick certain words and issue spot from there. If I can issue spot and I understand that there's this specific black letter law that I'm supposed to remember and I just don't remember it, I'm going to make up the black letter law. So I'm going to make it up to the point where if I, let's say, remember two out of three elements and I have just no idea what the third element is, I'm not going to forget and just put two and forget that the third one exists. I'm going to put a fake third one in there that kind of sounds of what I remember. If I don't remember anything, but I know that I have to talk about this specific black letter law, I'm just going to make the entire thing up. And I'm going to make it up to the point where I think it sounds pretty reasonable, right? And so if I forget the specific language that I have to say, I'm going to say things that kind of sound like that language. If I forget that specific word that I have to use, I'm going to talk about things that sound like that word, right? Kind of on par with what I think I'm supposed to write. But I'm going to make it up, right? I'm going to make it up as best as I can. But after I make it up, I'm not just going to be like, wow, I screwed that up and move on with my life. I'm going to apply my made up law to the facts. So just like this, if we forgot about what agency was about this tire contract, I'm just going to make it up that LLC members, and again, I don't want to make up law right now and confuse you guys. This is made up, by the way. LLC members can enter into agreements as long as it's reasonable within the LLC, right? Something like that. This tire contract is reasonable because they have a tire store and it's a similar type of business. Therefore, this is a reasonable contract and they're bound by it, right? So whatever my fake rule is, I'm going to apply it to the facts that I'm given to close that gap and at least get some points because made up law will get you something if you analyze it comparing to the facts and conclude. Does that make sense?
Yeah, that makes a lot of sense. So just
Okay.
basically remain confident in whatever you're doing, even if it doesn't make sense to you. Like try and make it make some type of sense from the facts.
Correct. Try to make it some type of sense and do not just be like, I lost on that. I'm moving on. Never skip. Put
Okay.
something down that kind of makes sense in our heads, apply to the facts and move on. And I understand like I'm doing something I know is wrong, right? Because you don't remember the issue spot and you're writing something that's wrong, so it like doesn't feel good, and I
Mm,
understand that. But I think try and get just like at least a couple sentences of a paragraph together to like finish that part and then move on.
okay.
And again, like this 1 through 4, if I don't know 2 and 3, but I know 1 and 4, I'm starting with 1 and 4 because these don't really tie into each other. I want to do the ones that I know first to feel good. And then I'll make up my lies on the other one, but you still can get points for making up fake law. And I've seen it before where people can make up things and still get a lot of points on their MEE.
Okay.
Not
Thank
the end of
you.
the world. No problem.
That happens a lot with criminal for me. Like criminal, sometimes I'll know ex like what it is, but I can't always remember all of the elements. So,
And there's a lot. There's a lot. As long as you get enough of them on there, and if you know there's others, just make up the others, right?
okay.
I
Okay.
wanted to follow up on that question. Sometimes when I'm writing or practicing to write MEEs, I find myself kind of explaining the law more so than, reciting the rule statement as it is in my notes or in my outlines. And that obviously takes a bit more time while I'm trying to, make the law make sense while I'm writing it. And a lot of
Hmm.
the times also, and I'm sure that a lot of you guys can understand what I'm saying, but sometimes while I'm writing the rule and trying to explain it, I'm still remembering the different elements. What do you suggest, like, because I know like memorizing all the rule statements is just going to be impossible, but like, how can we kind of get over that and make it kind of sound like it's the actual like rule, not just like me explaining it? Because in my previous exam, I did lose points where I thought because I was like over explaining the law because I couldn't remember it too well in like comparison to the actual black letter law.
Yeah. Um, so when we're writing the black letter law and we don't remember it exactly, but like you said, you want to explain it the best you can. Um, one thing is you got to know when to stop, right? You don't want your
Oh,
rule statements to be half the page and then your analysis is really small. So know how to stop explaining because eventually the grader is going to get it, right? Especially if you don't put that black letter law down that they're looking for. However, and you've seen in maybe online resources or outlines or other materials that the black letter law, like the perfect black letter law, changes slightly in different things that we've seen. So I'm not saying that there is an exact sentence that everyone has to put down on their paper if they issue spot third party beneficiaries and contract law, like there's not a specific statement that you have to say. There's probably 1 or 2 words that are like high ticket items that they're looking for, and the rest you can kind of get away with your explanation part. So I don't
okay.
think you should look at the black letter law like I have to memorize this exact word for word because then you'll just overwhelm yourself. I think if you memorize it as like a gist with certain words that will
Mm,
trigger is easier, right? Because I
Right.
know that the gist of it, and if you understand the law, it's easier to memorize than just like word salad on a paper. And so again, if you say like for example that unequivocal, they love the word unequivocal.
mm,
So if I can put that on the paper and the rest of it is like the gist of what the issue is, you'll get more points than just having like a random rant of you trying to explain it to them and them getting confused.
okay.
Because again, your grader is a normal attorney, right, who's been looking at MEEs all day long. And the last thing they want is to look at something that they're like, I have no idea what's going on, right? And eventually, if you maybe 2 or 3 sentences of explaining just move on after that. Um, because that's typically like how your rule statement would be, right? Your black letter law would be 2 to 3 sentences. So then you have 2 or 3 sentences of explaining what the black letter law is if you don't remember.
Okay. But memorizing the keywords, kind of like just find buzzwords for each rule that you think could be relevant and
Yeah, the
memorize that.
buzzwords and then like the gist around it if
Mhm.
memorization for you is difficult. And I understand that. Like if we're talking about offer acceptance and consideration and contracts, I'm not gonna, even when I'm writing, I'm not gonna have the exact, this is what an offer is, this is what acceptance and this is what consideration is every single time. My sentences will be different, but I'll have the gist over it
Yeah.
where again, and like we like to say, an unequivocal expression of intent to enter into a contract, right? That's something that we want to say. So if you don't say those exact words, it'll be like the gist of it, right?
Got it.
Um, but yeah, those are great questions. So, but again, I think the more preparation, and again, in this week, you can get a lot done in this week. The more preparation you do, seeing different MEEs and getting just used to the way that they explain things, can help you when you see your MEE not be like totally overwhelmed seeing the words on the paper. Because I feel like in the comfort of our homes, we can probably do way better issue spotting just because we're relaxed. And I think on the test, trying to relax yourself the most, you'll be able to see things that, if you were in a high intensity, like mental state, you wouldn't. And again, if I've said this before, but if you look at your first MEE, flip the page, and you're like, hell no, right? I am not doing this. If it's Civ Pro or something that you hate, skip it, right? There are other MEEs there. There's something that you're more comfortable with. Look for that one and do it first because you'll be in a better mental state to do the hard ones later. I definitely think it's all about like making yourself feel good.
Rebecca, I
Um,
have one more question. Sorry to
yep.
hold up
No,
the
that's
class.
okay.
Just quickly, for the Florida exams, I heard them talking about underlining and using bold and all the rest of it, and they didn't really talk about UBE as much. Do we need to do that for ours? Do we need to like bold keywords and underline phrases? Is it going to be better to do it
I
that
would
way?
I wouldn't say underline or bold your actual bodies of your paragraphs are important, but underlining or bolding our headings I think would be important. Because again, you are trying to make it easier on your grader. If the eye is catching, this is where I'm starting my first, this is where I'm starting my second, and this is where I'm starting my third, your grader will be like, oh, I understand the flow of this essay. But in the individual, like if I'm bolding unequivocal, you don't have
Don't
to do
bother.
that. I think
Okay.
just the subtopics, especially like in this, I would have my issue would be number one bolded, right? My issue number two would be bolded. Um, and that would allow your grader to be like, where is everything starting? And of course, when we do the issue is blah 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 blah. The rule is blah blah blah. Here, the facts suggest that da 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 da. Therefore, likely the person will be liable, right? I want to know, my grader wants to know where does my rule statement start, where does my analysis start, and where does my conclusion, right? Because we have to conclude, right? Don't forget about the conclusion. People forget about the conclusion. If you don't know, pick one, right? Wherever your facts are leading you. Um, and like I said before, I hate CRAC because if you conclude first, you box yourself in and you don't know what the answer is until after you do your analysis. So doing IRAC, I think, is way more helpful because once you weave in your facts and you kind of understand where it's going, then you're able to conclude where the facts are pushing you. Because typically the facts will push you one way or the other. Just like in this situation, I know I'm not going to really talk about formate, formulating an LLC, creating an LLC, because that's not where my questions brought me, first of all. And second, I had like one sentence that there's an LLC. Don't worry about it, right? It's pushing me to like, where is the problem here, right?
Mhm.
Your problem will present itself to you with how many facts are given to you about that problem.
Okay. Thank
Do
you.
you
Yep.
usually read the questions first before jumping into like reading the question, like the reading the whole fact pattern, or
So,
and right.
um, so that to me is so personal depending on the person.
Okay.
I like to start from the top down. I like to read my questions last.
Okay.
Just because I'm the type of person that if I start reading these questions, I will freak out because I don't know what's going on yet, because I didn't read yet. But once I get the idea of who my people are and what's going on, then I'll be like, oh, let's see where they're trying to get me to talk about something. And this will look familiar to me because I just looked at it. If you are a different type of person and you want to know where to focus, and I totally understand that, like this will shorten your focus to specific things that they talk about here. So maybe I don't waste the time thinking about, oh, well, the LLC was, filed, right? Is there going to be a problem about the filing? I understand that maybe it doesn't waste time like that, but for me, my brain likes top down. I don't like scrolling back up. That's just me. But please, if you're the person that's like, I need to know where to focus, I totally get that. Read the questions first, and if that's how you've been doing it, it's stylistic, right? Not everyone's going to take the test in the same way, but that's just how I always did it. Um, but that to me is stylistic. But I'm a huge proponent on IRAC. I think everyone should be IRACing. When I see a CRAC, I'm like, wow, bold.
Confident. Yeah.
Because you never know, right? You could be C-racking wrong, you could be concluding wrong, and then your grader is looking at something like, wow, this person's wrong, right? Because if you're wrong at the end, that's different from being wrong in the beginning and having a grader read your entire analysis thinking you're wrong,
Yeah.
right? So I just, again, you're writing these for a person to read. So you want it to be easy on them.
Okay. Thank you.
Yep. Okay. So, a defendant was tried before a jury for robbery that occurred at JoJo Bar on November 30th, probably in a crim law, possibly a crim pro. Let's keep going. At trial, prosecutor called the police officer who investigated the crime. On defense counsel's objections, the officer testified as follows. So, once I'm testifying in a trial, I want to put my evidence cap on, right? This may be mixed with evidence just for the mere fact that we are testifying. There's a block of testimony, and I'm probably going to get asked if this can come in or not. So, yes, I have my crim pro um, situation that I want to think about, i.e., Miranda rights, but because that will also have validity of the statement to come in. But at the same time, I want to also keep my mind open that this might be an evidence question. So, officer says I arrived at the defendant's home on the morning of December 1st. Um, and let me just 1 second, X this out. Okay. I arrived at the defendant's home on the morning of December 1st, the day after the robbery. He invited me inside, and I asked him, did you rob JoJo's bar last night? The defendant immediately started crying. I decided to take him to the station. Before we left for the station, I read him Miranda warnings. He said, get me a lawyer, so I stopped talking to him. So what the heck is going on in here? Invited me inside. So, is there a problem if he's not on the premises lawfully, right? Did he have to get a search warrant or entry warrant if he was invited inside, right? That's where my mind is going. Did you rob JoJo's bar last night? He was told a statement that's likely to elicit an incriminating response. That to me is a Miranda warnings issue spot. I want to know you need to be in custody and you need to you need to be interrogated for your Miranda warnings to be given to you, right? If those Miranda warnings are not given to you, then any statement that you say will not be allowed in because it's a violation of Miranda, right? However, I know he was probably said an incriminating, he was being interrogated here because did you rob JoJo's bar last night to me is likely to elicit an incriminating statement. But was he in custody, right? He's in his own home. Do you feel free? Does a reasonable person feel free to leave their own home whenever they want? I would probably make an argument and probably say he was not in custody, right? Because custody is typically in the back of a police car, or I'm in the station, or I'm on the side of the road in handcuffs, right? That to me is a custody situation. Um, so that is my issue spot for that situation. Um, but at the same time, prosecutor says, did the defendant say anything else to you? I think he did. I don't remember exactly what he said. Okay, now I'm probably getting into some type of evidence question, right? Because as soon as I see he doesn't remember what he said, I'm probably going to have a recollection recorded to try and refresh his memory. That is just where my mind goes when a witness on the stand is testifying that they do not remember something. When that happens, I have immediately my evidence blinders going up saying that to me looks like a recollection recorded and I'm trying to refresh. But let's see what happens. And just because I know I'm in this evidence flow, I also want to look at this in the context of evidence, right? Because if I'm trying to get in a statement, if it's a statement made against the opposing party, right, that to me is opposing party statement, right? So again, if the defendant who's sitting right there if he said something to the police and the police are saying, well, he told me that he robbed the store, that would be an opposing party statement. That is the defendant's statement being brought in and used against him. So that is an exception to hearsay, right? So I might have to do a little hearsay analysis here when I want to say, is this brought in for the truth of the matter asserted? And then I want to say that maybe this is an opposing party statement, right? So that's just where my mind goes when I read this paragraph. And especially because I have an evidence push, I want to look at each of these under the context of an evidence analysis as well. Um, so immediately after this testimony, the prosecutor showed the officer a handwritten document. What is it? The officer identified the document as notes she had made on December 2nd concerning her interactions with the defendant on December 1st. Prosecutor provided a copy to defense. The document stated this. So, what are my elements for recollection recorded, right? They need to be made in when the event was um, fresh in the person's mind, right? Um, we have, I'm just pulling it up here so I don't botch it. Um, It was, yeah, so they can't recall currently. It was made fresh in her mind when she made it. They were made by the actual declarant, right? The witness that is on the stand actually made by her. Um, and it was made under a time where the event was occurring, right? So it was around that time that it was occurring. So if that's all happening and she's saying she doesn't remember what's going on, that to me is recollection recorded, trying to refresh. And then I have my rules about that. So, what does the document say? Defendant burst into tears if he committed the robbery. He then received and invoked Miranda rights. I stopped the interrogation. I didn't ask him any more questions, but as soon as we arrived to the station, the defendant said, I want to make a deal. I think I can help you. I then reread Miranda warnings to him, and at this time, the defendant waived his rights and said, I have some information that can help you. When I asked how he could help, he said, forget it. Want my lawyer. Defendant's lawyer arrived 30 minutes later. Defendant was then released. So I have another Miranda warning situation here. I possibly have another statement against opposing party here because it's his statement being used against him if I have to bring that in. I have a waiver of Miranda, right? I need a waiver of Miranda to be voluntary and knowingly, right? So I want that to be an issue spot for sure. Um, so when I have a waiver of Miranda, um, that's one thing, right? If I waive my Miranda warnings, then I can just say anything voluntarily to the police and they can use that against me, right? However, while I'm talking to the police, even if I waived, I can always ask for a lawyer. And as soon as I ask for a lawyer, the questioning has to stop. So that to me is the parts of Miranda that are relevant to the situation, right? Because in my Miranda warnings, black letter law, it can be a huge page long if I really wanted it to be. There's a lot of black letter law about it, but I want to be able to parse the specific black letter laws that are relevant to this for time purposes. So to me, the big one is waiver. and its right to counsel, right? So the officer then testified, after reviewing your notes, do you remember the events? Right? They're trying to refresh her memory. She's saying no, but I do remember making the notes after I spoke with the defendant. At that time, I remember the conversation clearly, and I was careful to write it down. So in this situation, we have a document that was trying to, have this officer refresh her memory. And then over defense counsel's objection, the officer was permitted to read the document to the jury. The prosecutor also asked that the notes be received as an exhibit, and the court granted that request. So that to me is a red flag for sure, because when I have a recorded recollection being given to a witness on the stand trying to refresh their memory, um, you can enter that as an exhibit only on cross-examination. And they test this all the time. But you can only read it into evidence as the witness on the stand. So the witness can read it into evidence. However, if the opposing counsel wants to get it into evidence as an exhibit, they can do so only on cross. So on direct, when the prosecutor is asking the officer, do you remember this? Right? And they say no, okay, read from it. They're reading it into to the jury, right, out loud. And then how do we get that document into evidence? Right? How do we get that as an exhibit? When it's an exhibit, the prosecutor can't do it. It needs to be the defense that then asks the police officer, by the way, are you sure, on cross, you are crossing a witness that is not your own, right? The prosecutor put the officer up there. So the defense would be crossing the witness, crossing the officer, and therefore allow this to be introduced as an exhibit. So that to me is what I'm issue spotting here, where the document can be admitted on cross, but only on cross. And then here, the document was admitted um, with the prosecutor's request. Big no-no, right? I need it to happen on cross. This is the prosecutor's witness, so this is on direct. Does that make sense to everybody? Um, so then the testimony continued. Prosecutor, I'm just gonna check my chat. Yep. Um, Prosecutor said, did you speak to the defendant anytime after December 1st? Following my discovery of additional evidence implicating the defendant in the robbery, I arrested him on the 20th. Again, I read the defendant his Miranda rights. The defendant said he would waive his Miranda rights. Then I asked him if he was involved in the robbery at George's Bar. He said, I was there on November 30th and saw the robbery. I had nothing to do with it. So what is happening here where the person is being released back into the public and then he's getting arrested, he has to be re-Mirandized, right? Does that sound familiar? So when you're re-Mirandized, and again, why is he re-Mirandized? Because when he was given his Miranda warnings up here, he waived his rights, right? So when you waive your rights and then you have to get arrested again, you have to be given your Miranda rights again, but you cannot be questioned until 14 days after you waive it initially. So that 2-week rule, when you waive your Miranda rights, you cannot be questioned again. The only way that you can be questioned again is if you're re-Mirandized after 2 weeks, and then the slate resets. But this problem is, to me, why they're giving me these dates, right? Because on the first, right, this was the second, either the first or the second, right? I think it was the first. Interactions with the defendant on the first, yep. He's waiving his rights, right? And then I'm getting told that he's getting arrested again on the 20th, where he's giving his Miranda rights again. That to me is why am I getting these dates? It's about re-Mirandizing. When someone goes back to the public after 2 weeks of waiving Miranda, they have to wait those 2 weeks, those 14 days, to then give someone the Miranda warnings a second time. And then once you re-Mirandize someone, then that person can have another chance to waive or voluntarily give a statement or ask for an attorney. But what a cop can't do is someone waives Miranda warnings and then they give the Miranda warnings again like 5 days later. No, you can't just keep giving my Miranda warnings like every single day and wait for me to just admit we have this buffer, right? We have that 2 week buffer. So that is what this is issue spotting for me. Um, so the defense counsel objected to the admission of the testimony as well. The court overturned the objection. Okay. So the defendant's trial for robbery was held in a jurisdiction that adopted all the federal rules of evidence. If I didn't think this was an evidence MEE already, this is definitely telling me that it is. So I know that I'm talking about evidence and I'm talking about Miranda warnings for sure, right? And sometimes they go hand in hand. But again, I want to be able to say that Miranda is either satisfied or violated, and this evidence rule is either satisfied or violated. So, admitting the officer's testimony when he started crying, and when he started crying, that is up here, right? So, when he started crying, I have hearsay. I want to talk about hearsay. I want to talk about the Miranda rights violations. Was he in custody or interrogated? And when I talk about Miranda the first time, because I might have to repeat some Miranda, um, when he gets re-Mirandized, right? Miranda might pop up again. When I talk about Miranda in the first question, it's okay to say see above for elements of Miranda, right? And then I don't have to repeat myself again, and I can go into some more in-depth black letter law about that specific Miranda issue that I see, i.e., waiving Miranda, because that is a specific question for that, right? So I don't want to, again, waste time talking about the black letter law for Miranda because there's a lot. Would I also say what Miranda is? Probably. You have the right to remain silent. Anything you say can be used against you. You have the right to an attorney, and if you can't afford one, will be appointed for you. Do I want to talk about all four of them? If I have time, yeah. I want to tell my grader that I know what Miranda is, and that Miranda is a big part of this MEE. So I would definitely say yes. And so the first one is, again, hearsay. Was the statement of crying hearsay, right? I want to talk about, is it a statement? Is it made outside of court? And is it being brought in for the truth of the matter asserted? Yes. And so I need an exception to be admitted, and the clear exception we have is opposing party statement, which a lot of people forget about, right? If I'm using this person's statements against himself and he's a party in this proceeding, he's either the plaintiff or defendant, that's opposing party statement, right? Defendant told me that he robbed the place. Defendant told me that he owes me money. Defendant told me that blah, blah, blah. That statement against opposing party. That's an easy hearsay exception to come in. So that's number one. Number two is all about recorded recollection, right? I want to know my elements for recorded recollection, their jogging memory. After reviewing that document to aid in the memory, then they can testify from their own memory. But if they are reviewing the document and they can't recall the memory still, then you can read it to the jury. However, offering it as an exhibit only on cross. Okay, that's that big thing in the second and the third, right? Because reading handwritten notes to the jury is okay if they cannot remember, right? Because what's the point of refreshing a memory? I don't remember, so I'm reading this document to remember, and then if I remember, I'm like, great, and I set it down and then I talk because I'm not putting in that document into evidence. I'm putting in my testimony into evidence, right? So that document just aided me in refreshing. If it worked, then I set it aside and I testify because it worked. I remember and now I can testify from my own experience. If I don't remember it still, if I'm reading it and I'm like, yeah, I definitely still don't remember it, then the document needs to be used, right? Because I don't actually remember it in order to testify. The document has to be used. So when the document is used, then we can read it to the jury. So number two is okay. You can read it into the jury, right? Again, reading it to the jury is different than offering it as an exhibit. Those are way two different things. Reading it to the jury is just I'm reading it right now. Offering it as an exhibit is they go to the jury room and they can look at it whenever they want. Do you understand the difference there? Um, Also, recorded recollection that we have going on here is an exception to hearsay. So I may want to say, see above for hearsay, recorded recollection is an exception to hearsay, allowing the the officer to read the notes to the jury. Okay. But can we admit it into the jury? Can we admit it to the as an exhibit for the jury to then go into the jury room with it? No, right? Because it has to happen on cross. And the prosecutor is talking to the officer. The prosecutor put the officer on the stand. So the prosecutor cannot cross the officer because it's on direct. The only person that can cross the officer is the defense. The defense is not even talking right now. Okay. That was a tricky one, but again, it's once we do something like this together, you'll like never forget it and you'll see it in the next one and be like, oh great, I'm so happy we went over this a week before the exam. So admitting the officer's testimony, saying I have information that can help rely you with the case. Um, so what is number four all about? That to me is a quick Miranda and a quick hearsay party opponent thing again, right? That to me is almost the same as number one. So it's okay if I say see above for the black letter law on hearsay and see above for the black letter law on getting Mirandized. Um, and therefore this statement seems to be a valid statement and it wasn't made in violation of Miranda. Because what happens when he says, I have information for you? Um, he was then given Miranda warnings when he was in the station, right? Um, I reread Miranda warnings to him, and then he voluntarily waived his rights, right? I would want to talk about how he waived his rights. And then after he waived his rights, he said, I have information that can be helpful for you. So if he waived his rights knowingly and intelligently, that statement that he told to the police can definitely come in because he waived his rights and he said that. He only asked for an attorney after he said that statement. So that statement was fair game. He asked for an attorney after he said it. So that's four. And then five is about re-Mirandizing, right? I was there on November 30th and blah, blah, blah. He was let out to the public. 2 weeks passed. I have to be re-Mirandized for that to be valid. And again, see above for rules of Miranda. I don't want to have to repeat myself a billion times. Okay, does that make sense to everybody? And I know that was long, but don't shy away from saying see above. But see above to things that I already talked about, not see above to I'm going to add another black letter law for three or four or five if this is now an additional black letter law that I didn't say in the beginning. Because in number one, if I talk about all the elements of Miranda, custody and interrogation, what is custody? A reasonable person to not feel free to leave. What is interrogation? Likely to elicit incriminating statements, right? That's a large black letter law thing that I want to talk about first. Easily, when I go to four or five, I can say see above for elements of Miranda. However, Miranda also needs to be waived knowingly and voluntarily, right? Then I talk about that. So see how I mean? Like you can add your black letter law on things you've already written above. That can save a lot of time.
Can I ask
Um,
you?
Rebecca,
Sorry. Oh,
sorry,
no.
would the confrontation clause be mentioned at any point in that question? Or no?
so the confrontation clause is where a defendant has a constitutional right to confront people who are accusing him of things. So confrontation clause would be like if a witness said, I saw him kill somebody or he told me that he killed somebody and then he leaves the jurisdiction. Then I have a confrontation clause problem because then the defense is not allowed to cross-examine that witness. That's a
Okay.
confrontation clause issue. Does that make sense?
Yeah. I just wasn't sure about the part when the defendant admitted something or he asked him some. I think it was near the beginning. The officer asked about something. I wasn't sure if it needed to be mentioned there or not, but it's fine if not.
Well, yeah, so there's no confrontation clause if the officers are interrogating somebody.
Okay.
There's no confrontation clause issue. It's only when we're in trial and I have a witness talking about a defendant and then leaving and not allowing the defense to cross-examine. Then I have a confrontation clause, which is, and again, and also this can come up where we have like hearsay within hearsay, and a witness
Mhm.
gets on the stand and says, my neighbor told me that the defendant killed somebody, right? Then I have a confrontation clause issue too, because the defendant never had the opportunity to cross-examine that neighbor. The neighbor is not even here. So again, confrontation clause is the defendant has to confront the people who are accusing him. Once I am able to confront and ask questions, there's no violation, right? That's allowing the defendant to do, and again, what is a trial? People are accusing all day long, right? But as long as a defendant has an opportunity to confront, i.e., cross-examine, there's no violation of confrontation clause. Does that make sense?
Yeah, thank you.
Yep. Okay. Um, I thought this one was a little bit difficult, but let's go through it. So, 6 months ago, a man visited family physician, general practitioner for a routine examination. Based on blood tests, the physician told the man that his cholesterol level was somewhat elevated. Where is this going? Right? A lot of background. Physician offered to prescribe a drug that lowers cholesterol. Man said he did not want to start taking drugs because he preferred to try dietary change and natural remedies first. Relate. I hate taking medication. The physician told the man that natural remedies are not as reliable as prescription drugs and urged the man to come back in 3 months for another blood test. Physician also told the man about a recent research report that shows a herbal tea made from a particular herb can reduce cholesterol levels. Where is this going? If we didn't think about this already, why do I have a feeling that this man is going to drink herbal tea and get super sick, right? That to me is just like things are gonna go wrong. This guy goes to the doctor recommends something, and he's probably going to get sick. So I'm erring on the side of torts, right? I'm erring on the side of physicians have a duty, they have a national standard, right? We don't have just a regular reasonably prudent person standard for a duty. We have reasonable physician, as it is determined by a national standard. So that is what is pointing out to me with the situation going on here. Okay. So the man purchased herbal tea at a health food store and began to drink it. The man also began cholesterol lowering diet. So now he goes to this health food store, right? What happens at the health food store? 3 months ago, the man returned to the physician, underwent another blood test. The test showed that the man's cholesterol levels had declined considerably. However, the test also showed that the man had an elevated white blood count cell. The man's test results were consistent with several different types of infections and other types of cancer. Over the next 2 weeks, physician had the man undergo more tests. The test showed that the man's liver was inflamed, but did not reveal the reason. The physician then referred the man to a medical specialist who was an expert in liver disease. In the meantime, the man continues to drink the herbal tea. So this this paragraph of facts is if I'm correct and it's torts and we're talking about duty, breach, causation, and damages, what is my breach, right? What does the physician have to do or not do? Well, yes, he recommended this herbal tea that may or may not be hurting him. But then what did he do, right? He ran a lot of tests. He referred him to a specialist. So these are just, they're not giving me this information for no reason. This is telling me what the physician is doing to try and help the man in the situation that he's dealt with, right? So, 2 weeks ago, just before the man scheduled a consultation with the specialist, the man heard a news bulletin announcing that the government is investigating, has found a type of herbal tea that the man has been drinking that was contaminated with a highly toxic pesticide. And something that I feel like can help us when we're reading MEEs on test day is just to be like, this is so dumb, right? Like this, like the world blows up in the MEEs. Like the randomest, craziest things happen in MEEs. You just like can't help to laugh to yourself. And I feel like I did that too when I was doing my MEs. I was kind of like, this is so insane. Like, of course, like this stuff would happen in my MEE and I have to like deal with this, right? And I always like self-deprecating humor when I was going through my MEs, I'm like, of course I got this MEE, right? And we kind of just have to have that thought and then be like, I'm locking in. But what we don't want to do is like, oh my God, my life sucks. I got this MEE that's so hard. Like we got to be in a good mind, right? Everyone is reading this next to us. It's not like we have this hard one and everyone else has an easy one. Everyone has the same test. So the investigation took place after the liver specialist at a major medical center realized that several patients with inflamed livers and elevated white blood count cells, like the man, were all drinking the same type of herbal tea that the specialist reported, this fact to the local health department. Okay, so long story short, there's a tea that is probably causing issues and health issues, and the physician recommended it, right? That's how it started. So that's where I am right now. And then again, he got it from the health food store, right? So how did that health food store get it? Maybe I'll know more about it down here. So all commercially grown herbs used for this tea come from country X and are tested for pesticide residues at harvest by exporters that sell the herbs in bulk to 5 U.S. companies that process, package, and sell the herbal tea to retailers. U.S. investigators believe that the pesticide contamination occurred in one or more exports warehouses in country X, where bulk herbs are briefly stored before sales by exporters, but they cannot determine, important, they cannot determine how the contamination occurred or what bulk shipments were sent to the 5 U.S. companies. The companies that purchase the bulk herbs do not have any control over the warehouse. There have been no prior incidents of pesticides contamination, and investigators have concluded that the U.S. companies that process, package, and sell the herbal teas were not negligent in failing to discover the contamination. So I have a lot of stuff going on in this paragraph. I'm probably confused, but then I'm going to take a little breath and take a step back and being like, well, I'm not going to fight MEEs first of all. So I know that they're not negligent in failing to discover the contamination. But I also know that Country X sells to 5 U.S. companies that process, package, and sell. So these 5 U.S. companies are all getting it from Country X, but it seems like they don't know which U.S. companies because we know that the country X is supplying the herbal tea, right? So it's coming from country X. That is determined. Because all the herbs used for the tea come from X. So it's coming from X, but we just don't know which of the 5 U.S. companies is the one that has the pesticide contamination in it. Because basically, long story short, in this whole thing is telling me that we just don't know, right? We don't know who of the five is it. It's one of the five. But it's important that either of the five do not have any duty to discover contamination. So what is this pointing out to me? I have product liability. I have a product that's coming in, and I have a potential liability for people selling the product on the market to consumers. As long as I have a product that hurts people or explodes when it's not supposed to, or gets people sick when it's not supposed to, it's a product liability. Product liability can either be strict or negligent, right? I'm likely wanting to talk about both if they don't point me in one way. But I know for strict product liability, I have a lot of elements, right, that I'm going to want to talk about and we'll go through. But I just want to see that we know why this is that issue spot, why this is products liability, right? And again, if I didn't think I was in torts before, I definitely think I'm in torts now, right? I have basic negligence with that doctor. I have products liability with this country X and 5 U.S. companies. And then what else do I have? I probably have something with that health food store. So packages of tea sold by different companies varied substantially in pesticide concentration and toxicity. Some packages had no contaminant. So that's even more proof of we don't know who, right? If it's saying that one US company has all of the pesticides and the other US company has no pesticides, obviously I know that that is the one that probably is the one that's negligent. But if I don't know which US company it is, because some have the toxicity and some have no at all. It's completely random either way. I have a problem with determining liability of multiple defendants, right? That is what the problem is for this product's liability. So further investigation has established that the levels of contamination and toxicity of the herbal tea marketed by the 5 different U.S. companies were non-existent. So there's no the mar for the herbal tea marketed by the 5 different companies were non-existent. So there was no levels of contamination and toxicity in the herbal tea that's marketed by the 5 U.S. companies. So that's also something that we want to talk about as well. So the man purchased all herbal tea from the same health food store. The man is sure that he purchased several different brands of herbal tea at the store, but cannot establish which brands. The store sells 5 brands of the herbal tea currently marketed in the United States. So it seems like they sell all of the brands that could potentially be sold on the market, right? So Then what happens? The man suffered permanent liver damage, sued to recover damages from his injuries. It's undisputed that the man's liver damage was caused by the herbal tea consumption. The man's actions are not preempted by federal, state, or regulation. Great, thanks. So basically, the third issue, without even having to jump here, is this health food store, right? And so I have products liability situation where I have multiple defendants and we don't know which defendant is causing that harm. And then I have products liability in the situation of the chain of consumption, right? And I know my chain is anyone on the chain can be sued as long as it's not changed or contaminated when left that person's control, right? And so again, what's the chain? We have the manufacturer, the distributor, and the seller. The seller, the health food store, they didn't create the product. They didn't manufacture the product. They're just selling the product, but they can still be liable in products liability just by the mere fact that they're selling the product, right? So we still want to talk about the product liability elements. We may have to say see above for my third as it relates to the second, because in my second, I know I'm definitely talking about it. But I'm going to want to conclude, likely, that because I know that anyone on the chain of distribution can be sold in strict products liability, that the health food store is likely going to be liable. But this situation, because of all the facts that I'm given, that we do not know who is liable here. It literally says that they're not negligent in failing to discover, and we do not know um, that the contamination and toxicity levels are consistent, right? We have no idea. This, if I didn't think what was happening before, I think the facts are pushing me that there is no proof of which of these five are negligent. And so if I'm unable to figure out that, um, then I have an issue, right? I can't meet my element that we have sufficient evidence that's showing that one of these US distributors were responsible, right? I have joint defendants here, but I don't have enough evidence pointing to one specific defendant. So if I don't have enough evidence pointing to one specific defendant, typically burden would shift to the defendants to prove that they're not negligent. And then therefore it's hard to pinpoint which of the companies has supplied the tea, and therefore we can't find them liable as a group, right? So that is the issue spot with the multiple defendant part. But we also know that the strict liability products, we need a commercial seller, which we definitely have here. We have a defective product, and defectiveness can be defective in different ways. We can have a design defect, a manufacturing defect, or a label defect, like a failure to warn. So yeah, I'm gonna want to probably talk about all of those and get all my points. It's defective when it left the hands of the defendant. Obviously, it was defective when it left. Um, it was foreseeably used. It was drank like a regular tea was supposed to be drank, and damages. The guy has liver problems, right? So it seems like it is a manufacturing defect, right? Because they have some contamination in there. It was defective when it left the company's hands. It was used in a foreseeable way, and it did cause damage. However, he cannot prove which of the five were responsible. So that is the problem here, is when we have multiple defendants and all of them have the same probably likely amount of possible liability, we just don't know which one. It kind of collapses in itself, and I cannot show negligence, right? So I'm unable to show negligence in this situation. But even if you went through this and you threw some facts in there and concluded that one of them is potentially negligent, and then you concluded that he can find one liable if there's sufficient evidence. Maybe that would be a weaker conclusion because they're looking for, I can't find any of them negligent because I can't pinpoint. You would still get a lot of facts again for having all of those strict liability elements, all the different defects, the three different defects, applying it to our facts. That is the bulk of the points that we should not miss. Yes, GOT?
Yes. So can when we can raise the issue of res ipsa loquitur when there is like multiple defendants issue?
So, so res ipsa is not what's going on here because res ipsa is accident speaks for itself, right? Um, when res ipsa is brought up, it's typically in a situation where the defendant has exclusive control of the premises. And this type of accident did not happen if there was no negligence. So the problem that I
Mhm.
have here is my five US companies do not have exclusive control because it's coming from country X. Does
Okay.
that make sense? Like the exclusive
Yeah.
control part would be if the grocery store doors that open and shut, and we've seen a question like this,
Yes.
get
Mm-hmm.
stuck and hurt somebody, it's a res ipsa because those doors are under exclusive control of the grocery
Mhm.
store. No one else is dealing with those doors, right? It's part of the grocery store and they are supposed to fix defective doors. So if someone gets hurt
Okay.
and we don't know what else happened, this type of accident would not have occurred without negligence and it's under exclusive control. That to me is res ipsa. But I don't see res ipsa here because I have this pinpoint where it's starting from, and we have defendants that are equally possibly negligent, and we just don't know which one. That's not
Which
res
one?
ipsa. Res
Yeah.
ipsa is one defendant has exclusive control over something, and something happens without having to prove negligence. Does that make sense?
Yeah, thank you.
Yep. Yes, Dina.
So I'm actually so happy with this question because I did it and it threw me off because I started to get confused between the I think it's like the Summer v. Tice situation and these undeterminable cause situation, and I get them confused because I remember reading an example where it's like one gun, two birds, or and then there's another situation where it's like two people are negligent. Their negligence is not sufficient to cause the accident or the damage, but combined, they will create that will be the accumulated
Yes.
negligence. But if one person is negligent, but it's not determinable, then or it's in the you can't distinguish between the sorry. Okay, now I'm confusing myself. I'll
No,
just
that's okay.
okay.
So you are correct. So you don't have to know case law, by the way, but yes, and I think what you're talking about is the model answer talks about Summers v. Tice.
Yeah.
So in Summers v. Tice, it was two people with the gun and they both shot and the guy was
Mhm.
blind, but we don't
Yeah.
know who did it, right? So in
Yeah.
that situation, what is negligence? Negligence is an argument, right? We have duty, breach, causation, damages. We have to know how much negligence, right? Typically is a percentage. The problem with this MEE situation is we have a strict liability analysis. So if these elements are met, which we talked about all of them, and they are all met, then we have strict liability. And what is strict liability? By merely doing it, you're liable. I don't have a negligence analysis where I have to prove that you had a duty and that you breached it and it was foreseeable. I don't have to prove that. As long as I can prove all my elements for strict liability, it's strict liability. But what the problem is for strict liability is all five of mine, they can't all be strictly liable, right? I need to pinpoint at least one to be strictly liable. It's a little bit of a heightened standard because strict liability is so, um, like once you're strictly liable, there's no getting out of it. But with Summers v. Tice, that's in mere negligence. So in mere negligence, yes, the burden shifts back to the defendants to prove that they didn't do it. So typically the plaintiff has the burden to show that the defendant was negligent. But in situations where you have multiple defendants all acting together and causing one um, like funneled harm, if I'm in regular negligence, where it's just duty, breach, causation, damages, there's no product liability, there's no strict product liability. If I'm in regular negligence, then yes, the defendants have to prove that the other did it. The burden shifts back to the defendants. But in this situation, I just have products liability. There's no shifting in products liability because once you're negligent, right? There's no, um, once you have done this deed, there is negligence, right? That's what strict liability is. Does that make sense?
Yeah, it does, and thank you for that. The thing
Yes.
that kind of confuses me, and it's not with this fact pattern necessarily, but when we're talking about the situation in Summer Vitae, because there's two different fact patterns that could come up. where it's either two people are both negligent, their negligence alone wouldn't have led to the harm. And then, so I can get joint and several liability from both of those defendants, right? And then there's
Yes.
the other situation, there's another fact pattern, which is the Summer v. Tice fact pattern, where it's like one person is actually liable, but I can't define who it is. So I will shift the burden on those two defendants to prove that they didn't do it, right? So
Correct.
there needs to be a clear distinction between both of them.
Correct. If you can't prove who did it, but definitely one of them did, then yes,
Hmm.
the burden shifts. If you have multiple defendants and they all did a different level of harm, but if
Yeah.
you took one out, then he still would have gotten harmed, then yes,
Hmm.
you have the regular argument that you would make, and then it's about allocating the
Yeah.
liability to each defendant.
Okay.
And situations like that is where you have like a car accident where there's like five cars that are crashing into one person. You
Yeah.
would have to prove that who's contributed the most, right? That person
Yeah.
would be the most negligent.
Yeah. Yeah.
But again, negligence is always like a percentage, right? And it depends on what jurisdiction we're in, if we're pure or partial. But again, strict liability is like once you are strictly liable, you are strictly liable. And I'm not, I have no argument otherwise.
Okay.
Um, but yeah, I thought this one was difficult because of just like what they were talking about. But to have it more digestible. And also we didn't even talk about this, but this is duty breach causation damages, right? Typical for physicians, we have that different duty for physicians where they're held to a national standard. It's not a reasonably prudent person. That's the big issue spot that we want to talk about here. This is the possible breach of what he did. Right. So again, it's kind of up to you how you want to conclude if he breached or not. Was there enough evidence in the scientific journals that this doctor is studying or national doctors are studying for him to understand that this herbal tea could possibly be contaminated? Maybe not because there was a news bulletin that just has this government investigation later. Therefore, maybe this doctor wasn't negligent because there wasn't enough information when he was given this recommendation to the man. Just seeing the facts, right? That's kind of what the facts are telling me. Um, and then I have my strict products liability because I have a product that is causing harm, right? I have tea that is causing harm. And then I have another strict products liability on the chain of distribution for that health food store. And the health food store is hard to get out of because I'm just suing the health food store, right? If I'm suing someone in the chain of distribution, then it's easy to prove strict liability, get all my elements, as long as I'm in the chain and it wasn't substantially changed when it left the chain. Not like the man added some chemical to it before he drank it. That would be substantially changed. Health food store can be liable, right? But the difference is here I have multiple defendants and I don't know which one. And I'm in strict liability. Um, but I thought that one was long and difficult. Dog just opened my door. Um, so yes, Sheetal.
Sorry, can you remind me which MEE this is, please? This question.
This is number 3 in July 2016.
Okay, thank you.
Yep. Okay, let's go to 4. Um, so 2 years ago, and this one, I'll just say it now, is like something that you need to know the parties. Once you figure out who the parties are in this one, it'll be way more easier. So 2 years ago, PT treatment, PTT, because there's a lot of PTTs and who else? Incorporated in A decided to build a new $90 million proton therapy cancer treatment in A. Okay, so they're building something in A. Total cost to PTT purchasing the land and constructing the building to house the treatment facility was $30 million. PTT financed the purchase and construction with the 10 million of its own property and 20 million borrowed from the bank. As soon as I have money borrowed from the bank to purchase and construct something, probably in secure transactions, I have a PMSI. I can see it from a mile away. What is a PMSI? I take out a loan and the collateral is something that my loan is being used to purchase. So what that difference is if I don't have any money and I need to get a loan from the bank, and I borrow $400,000 and my collateral is the house that I purchased with that $400,000 that the bank gave me, they have a PMSI in my house. The house is the collateral that the loan was used to purchase with. That is a PMSI. The difference is if I have existing equipment in my farm company that I've had for 20 years and now I need a loan. I go to the bank and I get a loan and my collateral is my equipment. I've already had this collateral for 20 years. I'm not using that loan to purchase my collateral. My collateral's already here. That is not a PMSI. So see how this is a PMSI? So that to me is secure transactions. And if I thought this was real property because I have a mortgage, maybe, but once I get into this paragraph, we know it's secure transactions. And I kind of like secure transactions because it's typically just attachment and perfection, right? I have like the same elements for both. For attachment and perfection, those elements are repeated a billion times. And to me, that's kind of like a simple one, but maybe this one has additional things that we can talk about. Let's see. To secure the obligation to the bank, PTT granted, oops, PTT granted bank a mortgage on the land to all structures erected on the land. Okay. So we have a mortgage on the land that also extends to all structures, right? So maybe they create another structure that would fall under this mortgage, and if the mortgage is defaulted on, they can then get all structures on the land, right? So the mortgage was properly recorded in the county real estate records office, but it was not identified as a construction mortgage. Okay. Um, So let's see. 2 months after the mortgage was recorded, PTT finalized an agreement for the purchase of the proton therapy equipment from Ion Medical Systems for 60 million. What is happening? PTT gets PMSI from the bank. That is the first creditor. I know PMSIs are like super creditors, right? They typically pierce others, but it was done first, right? It was used to purchase the collateral anyway. It was used to construct the facility that is now my collateral, right? The land is the collateral. So that to me, because it was done first, has priority. And now I have a second creditor coming in. I have Ion Systems, Ion. Second creditor comes in and purchases the equipment for $60 million. PTT made a down payment of $14 million and signed a purchase agreement. Once I say purchase agreement, I know I'm in secure transactions, promising to pay the remaining $46 million in semi-annual payments over 10 years. The purchase agreement provided that Ion had a security interest in the proton therapy equipment to secure the PTT's obligation to pay the remaining purchase price. So now PTT's equipment, that is probably being held in this land has a security interest on it with Ion as the lender, right? So now Ion has a security interest in the equipment of PTT. Um, so let's think about it though. The equipment is the equipment part of the land, right? Is the equipment fixed onto the land? Because if it's fixed onto the land, then the bank might be like, hey, I already have a PMSI on everything that's been constructed on this land, right? So maybe that pops up. So over the same day, Ion properly filed a properly completed finance agreement with the Office of the Secretary of State. Seems like they perfected their security agreement, right? The Central Statewide Filing Office, thanks, listed PT Treatment Inc. as a debtor and indicated the proton therapy equipment as the collateral. So once I see this, I know that in my answer, I'm probably going to say what attachment is, what perfection is, right? These are all things that will get me a lot of points. Shortly thereafter, Ion delivered the equipment to PTT, and PTT's employees installed it. So now that they're installing the equipment, it seems like it's being, oh, look, attached to the building in such a manner that under state law is considered a fixture. Great. So now what's going to happen? The bank's going to be like, hey, I have a mortgage on all that stuff that's part of the land, and now Ion, the second creditor that has a security interest in the equipment, is probably going to say that they own the equipment once there's a default, right? And who's going to default? PTT is not going to pay back their loans. So let's see what happens. New PTT Cancer Treatment Center opened for business last year. Unfortunately, it was not an economic success. Shocker. For the short period, PTT contracted with State A Oncology for the later use of proton therapy equipment pursuant to a lease agreement. Okay, so now we have oncology using the proton therapy equipment pursuant to a lease agreement, but oncology failed to pay the agreed fee for the use of the equipment, so PTT terminated that arrangement. To date, PTT has been unsuccessful in the efforts to collect the amounts that oncology still owes it, so now PTT is owed money from oncology. PTT's own doctors and technicians have not attracted enough business to fully utilize the cancer treatment center or generate sufficient billings to meet PTT's financial obligations. PTT currently owes ION 30 million in its default under the security agreement. ION is concerned that PTT will soon declare bankruptcy. So a lot going on here. Um, but we have a oncology lease payment, right? So we have oncology is leasing the proton equipment therapy and paying PTT, right? So typically they were paying, but then failed to pay the agree upon equipment, so they terminated the arrangement. So the question that I'm probably going to be asked here is, can a proceed that is being paid to someone who's owing money. So PTT is owing the bank and owing Ion a lot of money, right? If PTT has people paying it from this lease agreement that oncology has, then those payments that PTT has can probably be paid to their creditors. So that is what is happening is proceeds from the equipment, right? Because they're contracting to use the equipment. Oncology is saying, I'll pay PPT if I can use the equipment. The equipment has a security interest on it, right? Might be owned by the bank or might be owned by Ion, depending on what my facts are telling me. But if I have someone using equipment that has a security interest on and then paying PPT as proceeds, proceeds might be attached to my security interest. Um, and therefore they might have the lender might have the right to receive payments from that lease. So that is what that's telling me. In a few days, Ion will be sending a technician to PPT facility to perform regular maintenance on the equipment. Ion is considering instructing the technician to complete the maintenance and then disable the equipment so that it cannot be used by PTT until PTT pays what it's owed. So what is happening? The technician is going onto the property and trying to disable the equipment. If there's a default, can they use self-help? Typically, yes, without breaching the peace. Sound familiar? So that to me is what I'm issue spotting there. So before I jump the gun, in view of PTT's default, if Ion disables the proton therapy equipment, will incur liability. That's about a lender trying to resort to self-help and get their equipment back. I'm probably going to want to talk about what a security agreement is and how I perfect that, right, in my initial question so that I can just say see above for future ones. Um, but what is my security agreement? Secured party gives value. Security agreement is authenticated by the debtor, and the debtor has rights to the collateral. So I apply all those things. Seems like I have a attached security interest. And therefore, because I have an attached security interest, that is valid, right? So once I have an attached security interest, perfection just perfects it to third parties, right? Perfection just means that if there was another creditor out there and they want the same collateral, we're going to have a fight about it because we need to know who perfected first and if the perfection was valid. But once I have attachment, I don't need it to be perfected to then collect, right? It just is a priority for different people in the world out there. But attachment for my security interest still allows Ion, in this case, to go collect the collateral once there's a default. There's nothing stopping Ion once they have an attached security interest with all my elements met to go collect the collateral. But they can collect it with reasonable self-help methods as long as they do not breach the peace. So repossession is what the first one is asking me about. And so what is my second one asking me about? If PTT does not pay debts to either bank or Ion, which of them has a superior claim to the proton equipment? Well, this is where I want to talk about what a PMSI is. PMSI is looking for my black letter law here. Wow, I don't think my model answer even said what a PMSI is. Well, that's fine. Well, PMSI, and so this proves that you don't have to put all the black letter law down to get the model answer. But a PMSI is where the collateral is the actual result of what the loan is, right? So the loan gives me $200 million. I use that $200 million for purchasing this land and building something on it. The land itself is the collateral, right? So that is what a PMSI is. So I have a PMSI versus a non-PMSI, and I want to talk about perfection, right? PMSI interests are automatically perfected within 20 days. So I know that PMSIs are they have high priority than other creditors. So typically PMSIs will be allowed to be collectible first to other creditors that are out there, but that's where my perfection is going to come in. And so I want to talk about perfection and how I can perfect where I can file a financing statement. Or sometimes I have automatic perfection, like if I'm getting consumer goods, right? Um, so that is number three, I mean two. And then number three, does ION have an enforceable and perfected security interest in any other PPT's assets other than the proton therapy equipment? If I'm looking at this, I'm saying, what other assets are they possibly talking about? I'm going to go up and I'm going to read this one more time because this is the other asset. This is the right to get lease payments. There was a lease. What is the lease? Someone pays you rent to use something on your property. PTT is receiving those rents. PTT is receiving the lease payments. If PTT is receiving something, then that is an additional asset that could possibly be taken by this creditor, right? By ION, who has an attached security interest on PTT's equipment, i.e., proceeds from that equipment as well, right? Because proceeds are always collectible if there is uh, a valid security interest, right? There's automatic perfection in cash proceeds. So that is where my number three is going. And so I want to make sure that, again, with every single secured transactions MEE, I have all my security interest attachment elements and all my perfection elements. And again, PMSI is a big one to issue spot. That's what they're looking for. I thought this one wasn't too bad. I know it was kind of confusing with like the medical stuff, but as soon as I understand like one and two, I thought were kind of like, yeah, I have resorting to self-help, and then I have just typical attachment perfection with priority. Number three is what other assets. If I missed that, then I'm going to go back up here and find the other asset. The other asset is the lease. Okay. Just check my chat. Okay.
Uh,
So I had, yep.
sorry.
No, that's
Um,
okay.
I wanted to, because whenever I practice secure transactions essays, I find that it takes me so long to write what a security agreement is, what attachment is, what perfection is, before I even start talking about analysis. And yes, I can refer to the first question in subsequent questions, but like, do we need to always define what a security agreement is, attachment, and perfection, or like right off the bat, or is there like can it be distributed a bit differently?
So I would say 99% of the time when I have a secure transactions MEE, I have to talk about attachment and perfection, and especially in this one because I'm asked if um that is here, right? And
Yeah.
even in here because I have attachment in the first one and then I have perfection in the second one. So you're gonna get asked about attachment and perfection in your secure transactions MEE, and if you don't, then I'll be very surprised. But that is how the reason I like secure transactions is because those elements can be written down and you can get a lot of points for it. So
Okay.
yes, I would definitely say what a security interest is, how those are attached, how attachment happens, and how I have perfected security interest, and if it is perfected, then who has priority if there's multiple perfections, right? And again, first and right is typically how we find out who is perfecting first gets priority. But yeah, I wouldn't want to not put those down.
Mm.
because that's how I get a lot of points in secure transactions. It's typically harder to pick up other points in secure transactions because sometimes you like might miss like again for this lease payment for the other asset, I thought that was hard to issue spot. And
Yeah.
if you miss that for some reason, you would be able to be like, well, I got a lot of points on attachment and
Mhm.
perfection. So that's how I'm putting that in my bucket because I'm going to bet that I got that and I don't have to worry about it. And if there is a more difficult issue spot, I can rest easy knowing that I have that cushion of points. Um,
Okay.
and I think that goes for other MEEs too.
Okay. Do we always have to talk about like what like the type of collateral it is, like defining if it's an equipment or a consumer good or inventory or is
So that is like a long one, right? Because we have different types of collaterals and you have to talk about either every single one. I would say that is like a secondary or tertiary issue spot. When they say it's like right here, they say it's equipment, right? I'm not going to want
okay.
to do this whole analysis on if it's equipment or not because they told me it's equipment. And just like in the other MEEs, if they tell me he's negligent, if they tell me there's a statute, I'm not going to like go into some long thing about that. I'm just going to take it as what they're saying. So in
Okay.
this particular MEE, I would say no. I would not talk about the different types of collateral and get into it because they're just being like, and it's equipment, right? They're not even telling me there's like an issue if it is or if
Yeah.
it isn't. But again, you might get a secure transactions MEEs that talks about like guitars in a guitar store. And then I have to
Yeah.
figure out, is that a consumer good? Is it inventory, right? Is it the guitars in the back? So that to me would be an MEE where the facts are suggesting that I have to talk about the different collateral, but in this,
Mm.
I would say no. So again, I don't want to say yes every single time you have to talk about collateral. I would say in the MEEs where the facts are
Depends.
telling you that is an issue. But
Mm.
definitely I would talk about attachment and perfection in every single secure transactions. And even if you're looking at secure transactions and you're like, I have no idea what's going on here, just talk about attachment and perfection. You'll get
Okay.
10 points by doing that, and then the rest will flow.
And do we have to always define what a security interest is or what a security agreement is? Because like that takes a bit more. Like when I write my um, secure transactions essays, I spend a lot of time defining what is a security interest, what are the elements of the secured security agreement,
Yep.
and then I go into attachment and perfection. And so that just takes a lot of time. So I don't know if there's like a necessity to adding the definition of what is a security agreement. And so,
Um, I mean, if it's taking you a long time, I would definitely just try and get at least attachment and perfection elements down. I think those are where you get a lot of the points.
okay,
But you don't really have to go on this like whole essay about what a secured transaction is. A security interest is just something that allows a debtor to collect something in case of a default. Right? You can dumb it down to like one sentence just to say like I know what it is and here's a quick summary of it. But I think the real points come from memorization of the elements and then connecting those elements to the facts, right? So the debtor has rights to the collateral. Well, the debtor has the right to the equipment, right? So I would want to connect it to the facts. And I think that's where a lot of points are being lost, is once I put my black letter law down, I'll be like, okay, now what's my next step? Go to my facts, find where each of these elements are connecting, and put that in my analysis. And I think the model answer in this one does a pretty good job. Um, but that is like where you get your points. So instead of going on a whole tirade talking about what that
mm,
is, save it, at least talk about your elements, get into a really good analysis and conclude. And then when you have a lot of time at the end and you're like, listen, I just want to add another fact, I want to add another black letter law or fact in there that I felt like I didn't put enough in, you can always go back and then type some more in. But for
okay,
time purposes, I think just
yeah,
putting the elements down is enough.
okay, perfect. Thank you.
Yeah. Um, okay, so five. I'm going to try and wrap up here because it's almost 9, but we'll be fine. So, a homeowner and a neighbor live in houses that were built at the same time. The two houses have identical exteriors that are next to each other. Homeowner and his neighbor have not painted their houses in a long time. Exterior paint on both houses is cracking and peeling. A retiree who lives across the street from the homeowner and the neighbor has complained to both of them that the peeling paint of the houses reduces property values in the neighborhood. Is this real property because there's houses? Is this torts because there's a nuisance? I don't know. Let me keep reading. Last week, the homeowner contracted a professional house painter. I'm in contracts, right? I'm in contracts because there was a contract and I don't have to think that hard, right? So they contracted a professional house painter. After some discussion, the painter and the homeowner entered into a written contract signed by both of them, pursuant to which the painter agreed to paint the homeowner's house within 14 days. The homeowner agreed to pay the painter $6,000 no later than 3 days after completion of the painting. I have some terms here that I'm kind of want to just keep in mind. I don't have to memorize anything yet. But I know that there's an amount to pay and when it's going to be paid and what the amount is going to be paid for, right? Painting a house. So price was advantageous for the homeowner because to paint a house of that size, most professional house painters would have charged at least $8,000. Okay, so I have a fair market value of what the painting should have been. Seems like he's getting a deal. Good for him. So who do I have? I have a homeowner contracting with a house painter, and then I have a neighbor that lives next door. That's the other house with the cracking paint. And then I have a retiree who's living across the street and is just upset about the condition of the house. So I have to know who's who, and that will help me. So the day after the homeowner entered into the contract with the painter, he told his neighbor about the great deal that he made. The neighbor then said that her parents were coming into town and that she was reluctant to invite them because it was the first time the parents would see the house. She wants to invite them, but it's peeling paint. I'd be too embarrassed. I'd paint the house, but I can't afford the going rate, which is probably at least 8,000, right? So what does the homeowner do? The homeowner, who was facing cash flow problems of his own, decided to offer the neighbor a deal that would help them both. The homeowner said that for $500, the homeowner would allow the neighbor to take over the homeowner's rights under the contract. The homeowner said, "Pay me 500, take the contract from me, and the painter will paint your house instead of mine. And when he's done, you'll pay him the $6,000. The neighbor happily agreed to this. What is happening? Seems like there is an assignment, right? When I have rights or duties to a contract that is already in existence, I have an ability to assign that to another person, right? So I can either assign rights or I can delegate duties, but they're typically called assignments, right? In one whole. That's just like colloquially what they're called. But what is a right? Assigning a right to get paid, assigning a right to get your house painted, right? That's like a benefit to you. And delegating a duty is like the duty to paint or the duty to pay, right? I have a duty. So I assign rights, I delegate duties. And if I have a contract that doesn't say you can't assign or you can't delegate, then I typically can do it, right? There's no restriction unless there's words in my language that tell me that I can't do it. Or if I do assign it, then there would be a substantial change in the nature, right? And so what does that situation look like? If I specifically got this painter that came from Italy that is very good at doing this specific type of paint, and I contracted with him, and then that Italian painter assigns and delegates his duties to another painter, I'm going to say no. You substantially changed the contract when you assigned that away from you because I asked for you specifically. So the assignment would be barred in that situation, but it seems like in this MEE fact pattern, I don't have any of that. So it seems like the assignment would be okay. I know I hate concluding first, but again, just for the nature of this exercise that we're doing together, it seems like the assignment would be valid in this situation because nothing tells me there's a substantial change in circumstances or that anything is barring the assignment. And so once I have an assignment, then what does that mean? Um, I have still rights to pay, right? So if that's the situation, then assignees are given full rights and duties under a contract, right? That means that the neighbor that then gets assigned has a duty to fulfill the rights and duties of what the homeowner originally had. So that means that the neighbor who accepted this assignment, right? Thank you for assigning me. I want my parents to see my beautiful house. They would have a duty to pay, right? They should pay the painter. But if they skip town and don't, because typically in the fact patterns, the neighbor will then be like, I can't pay. And if that happens, then the homeowner is still on the hook, right? The homeowner is still remaining liable for the contracts that they assign. So we don't have a expressed, like, I don't have any more liability anymore as the homeowner unless I have a novation to remove my liability, right? So that's the key that I need is a novation. So before I jump too far into this, That is what I'm thinking. I have an assignment. Is the assignment valid? Seems like it is. Once I assign, who is still on the hook to pay? Because that's always going to be the issue, because someone is going to skip town and no one's going to pay the guy, and they're going to have to figure out who to collect from. So typically in an assignment, the original contractor, the homeowner that originally contracted, is still on the hook, still has to pay if he skips town, unless there is a novation to substitute the homeowner for the neighbor with liability purposes. Let's see if we have that. Don't have it yet. So the following day, the neighbor paid the homeowner $500, and the homeowner said to her, "The paint deal is now yours." So again, when I assign, I don't have to assign for money, right? I can assign for free if I wanted to, but in this situation, just because that they're giving another $500, just allows a additional consideration to be used, right? And so that to me is like, well, I'm not going to say that changes the assignment or not. Um, I would say that that is just a way for these parties to understand that the assignor and the assignee and the consideration between them, right? So the $500 isn't really jumping out to me too much. So the neighbor then invited her parents over for the visit. The neighbor also remembered how annoyed the retiree had been about the condition of the house. So she called the retiree and told him about the plans to have her house painted. Retiree responded, "It's about time." Is the retiree an incidental or intended beneficiary? That is what this is going for, right? So when I have a third party involved in the contract in some way, I'm going to have incidental versus intended beneficiaries. I know that an incidental beneficiaries is just incidentally benefited by it, right? But an intended beneficiary is thought about before we enter into the contract, right? They are the reason that we're entering into the contract is to benefit them. If I'm just merely incidental, then you don't have any rights. If I am intended, I do have rights, but the rights have to vest, right? And the rights vest by either learning about the contract, materially changing position on the contract, or suing. Got it? So later that day, the homeowner and the neighbor told the painter about the deal pursuant to which the neighbor had taken over control of the contract. The painter was unhappy with the news and said, "You can't change my deal without consent. I will honor my commitment to paint the house I promised to paint, but I won't paint someone else's house." So painter's upset, but do they have any right to be upset? Probably not, right? Because the assignment was valid. There's no difference in the magnitude or difficulty between the work required to paint the homeowner's house and the work required to paint the neighbor's house. Great to know. That even goes a little bit more to the argument the assignment was valid because there's no substantial change in the contract, right? There's no substantial change in the painter's need to paint, right? Because if it was like a 10 times bigger house for the same amount of money, that's unfair, right? That would be substantially changing it. So what do I have here? I have general contract law, right? I may want to say something very, very quick about offer acceptance and consideration if I have the time. I have assignments of contracts, which are typically valid if nothing is expressly saying I can't, or there is no substantial change in the contract rights. I have who is liable for painting. Who is liable for paying if the party who was assigned it refuses to pay. Is the assignor still liable? Yes, right? The homeowner that assigned it away still liable if the assignee skips town. And then I have incidental or intended beneficiary third party rights. That is what I'm issue spotting here. So if the painter refuses to paint the neighbor's house, will the neighbor succeed in a breach of contract claim against the painter? Seems like they would, right? They would be able to collect. So in the first situation, neighbor would succeed in a breach of contract against the painter because we have to figure out if contracts are assignable absent any provision to the contrary, which we talked about, right? So that's about the assignment. Assuming that the neighbor would be successful in the breach of contract, even if it says assume this, I'm not going to change my answer in one if I said that the other way, right? Do not change your answer if it says assume. I promise you, it's just a bad idea. Would the retiree succeed in a breach of contract? That is incidental versus intended. This retiree is definitely incidental because he was not discussed while they were entering into the contract. They're not saying, I'm entering into this contract because I want this retiree to be happy, right? They were just getting the house painted. The retiree is an incidental beneficiary because he's just incidentally benefited by this contract going through, right? He's happy that it looks nice in the neighborhood, but he doesn't have any vested rights. He doesn't have any rights. So that would be my issue spot for 2. And 3 says if the painter paints the neighbor's house and the neighbor does not pay $6,000, knew that was coming, would the painter succeed in a contract claim against the neighbor, against the homeowner? Yes and yes. So what is the difference here? I don't have a novation. If I have a novation where we expressly get rid of liability for the original contracting party, where there's like some written or oral agreement and oral novation saying that the homeowner is off the hook and the neighbor is the only one that's liable right now, then they cannot collect against the homeowner because there was a novation, but I don't have that here, right? So that is the situation here. And I don't want people to get confused with assignments and subleases. I know it's very similar, but assignments and subleases, when you have a lease and you assign the remainder of your lease, or you sublease a portion of your lease where the original person then comes back, if someone does not pay, then there's the question of if you're liable or if the original leaseholder is liable. That is different than this contract situation where I have just an assignment of the contract rights without a novation, right? So again, assignment of the bubble is assigning rights and delegating duties together. They're just called assignments, but you're doing both. But again, who is assigning? In the situation, the homeowner is assigning to the neighbor. So the homeowner doesn't have any duties to paint. They have the duty to pay. So they have the right to get their house painted and they have the duty to pay. If the artist or the painter assigned their rights, then they would have the right to be paid assigned, like the new assignee would have the right to be paid and the duty to paint. So if I'm confused about what rights are being assigned or what duties are being delegated, I have to see who was the party doing it. That party, do they have the right to be paid or do they have the duty to pay, right? What part of are they on this contract dispute? And whoever they assign it to then collects what they're supposed to do, right? Does that make sense? We have to know who the party is to figure out what rights and what duties are being assigned. So I thought that was an easy one. So if I were flipping, I would probably do this one first because I like a simple contracts one. But that's just me. So this is not that long and we'll be finished in like 5 minutes, but I wanted to go over it even with time, just because I thought this was good to see that we could also get something like this on our exam. Woman and a man lived in their entire lives in A. Once I see state A, am I in civil procedure? I don't know. I always think of that. Why am I in state A? Am I in family law, right? Sometimes we have state A talking about family law, but those are just things that are popping in my head because again, I'm going to read this, right? I'm not reading civil procedure MEE, right? So the man once went to a gun show in state B where he bought a gun. Otherwise, neither woman or man has ever left state A. The following events have occurred. Seems like I have a minimum context analysis coming up because he goes to state B for one time to buy a gun, but maybe the gun results in this situation. So I have to figure out where he has minimum contacts to be hauled into court, right? Is there personal jurisdiction? That to me is what I'm issue spotting right away without even looking at the rest of the stuff. So, woman and a man went hunting for a wild turkey in, say, a game preserve. The man was carrying the gun that he purchased in B. He permanently disabled the gun's safety features to be able to react more quickly to a turkey sighting. The man dropped the gun and accidentally fired, inflicting serious chest wound on the woman. The woman was immediately flown to the hospital in C, and she underwent surgery. So now I have C, where the surgery happened and where she's probably going to recover. So let's see what's happening in A, B, and C. So A is where the accident occurred, where they went hunting. B is where they purchased the gun. A is where they live. I want to know that. C is where she went to the hospital to have surgery. And 1 week after the shooting, the man traveled to C for business and took the opportunity to visit the woman in the hospital. So now he's in C for business. She's in C to be in the hospital. During the visit, the woman's attorney handed the man the summons and complaint in a suit that the woman had initiated against the man in the U.S. District Court of District State of C. So now she's suing in C. I wonder why she picked C. 2 days later, the woman was released from the hospital, returned home to A, where she spent weeks recovering. Okay, so she's actually recovering in A, because typically they tell you where they recover. So why is she in C? She's in C merely for going to the hospital and having surgery. He's in C for business. He was not tricked into that state. He was there for his own initiative for business. So when I'm doing my um, personal jurisdiction analysis, I know I have my traditional methods, right, which is actually being personally served in the state without being tricked there, or consenting, right? I have my traditional methods, and then I have my minimum contacts test, which if I don't have a traditional method, I have to comport to minimum contacts, which is a whole analysis if I have general or specific jurisdiction, if I'm at home, or if I am purposely availing myself with the fairness doctrines, with the fairness factors. So I have my personal jurisdiction analysis that I'm going to want to talk about. That is where this is pushing me. So the woman's complaint alleges separate claims against the man, state law negligence, and a federal claim against federal gun and safety. If I'm suing in federal court, I know I have diversity and I know I have federal question. If I don't have either of those, I cannot get into federal court. If I have one of those and my additional claim is not a federal question or does not meet diversity, but it comes in under supplemental, then I'm able to get it in, right? Same transaction or occurrence. That is where this is taking me because state law claim is not going to be able to get into federal court, but a federal claim can be. And again, it's a federal claim arising. It's not a federal defense. Federal defenses do not get you into federal court. It's only a federal cause of action, a federal claim. The Safety Act provides as a cause of action for individuals harmed by gun owners who alter their safety features of a gun that has traveled to interstate commerce. That's exactly what happened here. The Safety Act caps damages $100,000 per incident, but does not preempt state causes of action, so she can still sue on state cause of action. The woman's complaint seeks damages of $100,000 of the Safety Act and $120,000 on the state law negligence claim. Both sets of damages are sought for compensation for the physical suffering of the woman and the medical costs that she incurred as a result of shooting. So, she is from A and man is from A. I don't have diversity. Do I have federal question? Yes, because I have a federal question. I'm in a federal claim arising under a federal state statute, federal statute for a situation that happened exactly like happened in our MEE. And I have also supplemental jurisdiction for the state negligent claim because it's under the same transaction or occurrence. Spoiler alert. The man has moved to dismiss the complaint, saying there's no PJ, there's no SMJ, and there's no proper venue. State C jurisdiction allows the state court to exercise personal jurisdiction to the limits allowed by the United States Constitution. So that's pretty simple. That's my minimum contacts, right? So again, minimum contacts is a minimum analysis, and my state might give me more protections, but cannot give me less protections. So if I have a long arm jurisdiction or a long arm statute in my jurisdiction that says if you specifically commit a car accident that hurts somebody, you can be hauled into court here, right? So that's an additional protection. Is yes, I have minimum contacts, but I also need to hurt somebody in a car accident, right? So a long arm jurisdiction can give an additional protection to someone, but it cannot take away protection. So I still have to comport to minimum contacts. So with respect to each asserted basis for dismissal, should the man's motion be granted? So looks like I don't have a typical 1, 2, and 3 situation. I have an A, B, and C because he's trying to dismiss the complaint with 3 arguments. I have a PJ, SMJ, and improper venue. And that is everything that I kind of issue spotted, right? The venue one is it's pretty typical in Civ Pro, right? We basically have venue and we're just bringing stuff into court. Look how small this MEE has. Look how small it is, right? It's 1 page. The other ones were like a page and a half, sometimes 2 pages. This is a very, very small MEE, but our answer might be a little bit longer just because minimum contacts for personal jurisdiction is a little bit long. And so this situation, because I have a big personal jurisdiction analysis and then I have a subject matter jurisdiction and venue, I'm going to want to be very cautious of the time. I know that PJ can go on and on and on about at home and general and specific and minimum contacts, traditional notions, right? But I want to make sure that I talk about what is happening in this situation. So I know there's a traditional method because he was served in the state, but he also has to comport to the minimum contacts analysis. However, I am just trying to figure out if he had personal jurisdiction in that situation, but what's happening in C, right? He was served in C, but I don't want to just conclude that there was a traditional method that was met and then move on with my life. I want to hit all the points, right? So I want to talk about all my personal jurisdictions, minimum contacts with the general versus specific. Yes, I want to say that traditional notion was met, but I still want to talk about the general versus specific to get my points. Um, but I do want to say that because the traditional method was done where he was personally served, then yes, there is personal jurisdiction over the man, even though there wasn't that many minimum contacts. Because I want to talk about that. I want to say that they were only there for the he was only there for business purposes and she was only there to have surgery, right? Where are they from? They're from A. The accident happened in B, right? So there's other things that are going on that are taking that minimum context away from C. But I still want to make sure that my grader knows that if there is a traditional notion, that's kind of like a done deal, right? Traditional notions are like the golden standard. If I have it, I'm good. I still want to talk about minimum context just so I can get the rest of the analysis on the page and get points. But I want to conclude that state C can exercise personal jurisdiction because of that traditional notion, right? So I thought that one was a little bit tricky. But I have my subject matter jurisdiction, right? I know I want to talk about diversity, even though there's no diversity, because I know there's only two methods of getting into federal court. I'm not going to talk about one of them. So I'm going to talk about diversity. I'm going to talk about subject matter jurisdiction. Sorry, federal question. And I do a federal question. I have supplemental jurisdiction for state law. And so that to me is proper, right? I can hear both of those claims. And then what is venue, right? Venue is proper where all the defendants reside if all of them reside in the same place, or if no different defendants don't reside in that place, or not all of them reside in the same place, then it's where a substantial part of the event or claims giving rise have occurred, right? And so I would write that exactly down. I have one defendant, he does not live in the state, can't get a venue proper with that situation. But what's my other way that I can get venue to be proper? If substantial amount of events occurred in that state, did not happen here, right? She was only recovering. Sorry, she wasn't even recovering. She was just getting surgery. She recovered at home, I think, right? Um, yeah, she recovered at home. So that all my facts here are pointing that I do not have proper venue. So he is definitely going to have it dismissed for improper venue, because of my black letter law for venue, I know is not present here. But I'm gonna get a lot of points by weaving into my facts of what happened in A, what happened in B, what happened in C. There's a reason that I have three states going on here, and I have a big PJ and SMJ and venue question. They're going to want me to talk about all those different states and what happened there, and that's going to be the fact analysis that I'm going to get a lot of points for. So I would definitely look at the model answer for this because I thought they did a good job in parsing through how much black letter law of PJ to write in that's appropriate because I understand that my PJ black letter law can literally be like a full page long. I understand that's possible, but with time we want to be careful, and I think that the model answer, there's two model answers. I would read them both. I think the second one, in my opinion, is a little bit better, but it kind of shows this is how much I would write with the time that I'm given. Because if I had all day, I could write a beautiful PJ analysis that is very long and detailed, but I don't really have that much time. So I'm probably going to write something that's around the same length as the model answer. Um, and again, this is very black letter law heavy. PJ has a lot of definitions. It has a lot of parts that is like a flow chart. And I think it's something that has to be really committed to memory. And again, if it's difficult for us to commit to memory, we can do the gist. But I think the big uh, words that they're looking for, um, purposeful availment, privileges and benefits of the state, things like that, right? They're looking for that. So if we can give it to them, we'll make them happy, and that's all they want, right? So, um, Yeah, I honestly agree with you, Ngozi. I like it. I like it too. So I thought this was helpful for you guys to just have some practicing issue spotting. Sorry that we went a little bit over time, but I thought in your last week it was it was called for. But so I'm going to stop the recording if there's questions.